Good morning, everybody, and welcome to the District of Columbia Court of Appeals. We have one case on this morning's special sitting, and it is Patrick Woodley Jr. versus Woodberry Village Apartment, number 23 CV 965. The council.
Good morning, and may it please the court. Fran Swanson for appellant Patrick Woodley. I'd like to reserve 3 minutes for rebuttal. The landlord made a business decision to break the law by refusing to repair Mr. Woodley's heat, refrigerator, ceiling, or address the mice infestation. It can't now avoid the consequences of that choice. In deciding otherwise, the trial court did not follow this court's decision in Walker versus Office of Chief Information Technology Officer. Under Walker, the trial court could not find a failure to mitigate based on the rejection of an offer without, quote, particularized findings explaining why turning the offer down was unreasonable with reference to whether the offer was, quote, comparable to what the landlord had to provide.
The place that you're starting your argument seems to assume that there is a duty to mitigate. Are you forgoing your argument that there's no duty to mitigate under the statute?
We are not, Your Honor, but we think that this is the narrowest way for the court to decide this case, where the landlord, as a matter of law, did not have evidence to carry that burden should it exist. We
might be narrow, but maybe the cleanest way is just to say there's no duty to mitigate, right? Because otherwise we have to look at the record, which is a little messy in this case. So can we talk a little bit about the duty to mitigate?
Of course, this is absolutely the wrong case for this court to hold for the first time in this jurisdiction or any other, that a tenant has a duty to mitigate when the landlord breaches its duty to maintain the unit in a habitable condition. We think that follows from Javins itself, which says, quote, that duty on the landlord cannot be waived or shifted, and to impose the duty on tenants to mitigate when the landlord concededly leaves the unit in uninhabitable condition would gut Javins. Javins also recognizes the fact that the landlord and the tenant are in completely different bargaining positions, and it's born out of that inequality that the burden to cure the landlord's breach or address the landlord's breach cannot be waived or shifted to the tenant by imposing on them a duty to mitigate.
I mean, all that.
An absolute rule. I mean, if I were a tenant and there's a natural gas leak in my apartment and I sort of detect that there's a problem and I call the landlord and the landlord rushes over and says, this is not habitable, you need to get out of here on an emergency basis, and I'm going to get people in to try to fix it. Would you say the tenant can lawfully stay in, suffer serious injury, and not have any kind of any duty to leave that might be reflected either in tort law if you're thinking about tort concepts, or that might be relevant to damages if you're thinking about more contract sounding claims?
So that would be a very different case, where there you're describing the landlord is attempting to repair, the government has stepped in and said it is not habitable for you, the tenant, to remain. But setting those differences aside, the Scoggins case, for example, this court said it is never a reasonable defense to say to the tenant, you should have simply moved. And that's because the law recognizes moving is not simply any mitigation measure. It is a really big deal. And so the landlord should have to pay for that violation of his implied warranty of habitability.
You're assuming when you're looking, I mean, we have to look at the statute, yes, right? I mean, there's a common law duty to mitigate. And it seems, I thought what your argument was that the common law had been overridden or abrogated by 42-3505-52 that just says there's a duty to mitigate by the landlord when the tenant breaches. Because why would you write that statute if you just wanted the common law to continue, right?
Yes.
It is narrowing the common law duty to mitigate.
Well, it does narrow that duty to the extent that the duty existed. The statute that you've cited shows that the council knows how to impose that duty in the residential lease context, and it never did that on tenants when it chose to do it on landlords. We would also argue, though, that Javins by saying that the duty to follow the implied warranty of habitability cannot be waived or shifted means that the duty to mitigate is never imposed on tenants in that context.
Can I ask you, does that mean, I mean, one way of looking at it is relying on the statute and thinking of sort of implied repeal of the common law duty. I guess another way of looking at your argument, I'm just trying to figure out which of these ways you're focusing on, or and I don't mean to limit you to one, is just as a matter of understanding the common law duty to mitigate. That's a duty that sounds like a lot of common law principles and reasonableness, and it's just not a correct interpretation of the duty to mitigate, that it's reasonable to expect tenants to have to move out of their apartments when they're rendered uninhabitable by the illegal conduct of their landlord. So it's not that there isn't a duty in the abstract, it's that it's not, the duty doesn't extend so far, because that's just not something that you are required to do. There's no duty to mitigate in that way as a matter of the common law concept. Are you making both those points, or?
Absolutely, yes, both of those points. So I think Javins means that the duty to mitigate does not arise for tenants in this context, but another clear and narrower way to view it is exactly what you've articulated. That sure, in the abstract, maybe there is a duty to mitigate, but mitigation cannot be that a tenant is required to move out. And as in any other mitigation context, we look to whether or not that would be reasonable. I think more evidence of the fact that it is unreasonable to require a tenant to move out comes from 3505.01 F1. And that is the very clear articulated scheme that the council enacted for when landlords can establish that they cannot repair a unit and instead must renovate it in order to bring it up to code. It's not enough for the landlord to just say, we want to renovate it. Instead, the council imposed a very detailed scheme there that requires the landlord to give tenants 120 days notice, requires 2 different government bodies to look at the plans, send an inspector on site who can say, yes, these are changes that need to be made, and they cannot be made with tenants living in them.
Do you think it would necessarily be reasonable then to require the tenant to leave if the landlord jumps through all of those procedural hoops from the statute?
If the landlord was to go through all of those hoops, I think it could be reasonable, if the duty exists, to require the tenant to leave. One other detail that I'd like to point out from the statute is the statute has the two different government bodies look at what is the offer that each tenant here is being given, and is that sufficient based on what they agreed to in the lease. But it also has the statute also evaluates what are the terms of that move out. So landlords need to say not just this is when we want you to leave, but also this is when you have the right to come back. What the terms of the lease will be when you return, how you will be returned. All of those things that the landlord never put on evidence to establish here in this case. Similarly, the landlord didn't do any of the things that it was required to do to show comparability under Walker. Of course, this court and no other court has ever imposed a duty to mitigate in this context. We think it should not do so here for the reasons that we've just discussed. But Walker tells us what are the things that we look to determine reasonability that the breaching party has to provide evidence of. And those are all the things that would be important to somebody in considering an offer. So there in the employment context, this court explained, the employer would have to show the precise job that the person was offered, the salary, the benefits, the prestige, anything that somebody would want to know in evaluating an offer. Here, all the landlord has pointed to is its September 10th, 2021 letter that's at JA 110, which says, Mr. Woodley, we are going to shut off your water in 3 days. Here's another unit you can take. Let us know by the end of the weekend if you want it. That is not an offer. That is the landlord saying, not only are we not going to repair these conceded breaches, we're going to put you in an even worse position if you do not accept this nebulous other unit.
Right. and I take that argument. I guess I'm still stuck on whether or not there's a duty to mitigate, because we don't even have to get to the question of comparability if we think, and I take it you agree with, I think, Judge Fleece's articulation of the rule that if the landlord has not followed the procedures under the statute to relocate a tenant does not have an obligation to move out so that the landlord can address habitability issues. Is that correct?
So one modification, Your Honor, it's not a question of renovating to address habitability issues, because of course, most habitability issues, including the ones in this case, can be addressed with the tenant in them. And that's why the statute is so specific. And that's why the legislative history of the statute says, we know that landlords are allowing buildings to fall into disrepair, and then they are forcing tenants out, offering them alternative units and telling them, look, you've got to take it. We're not going to repair any of the conditions in your apartment, which we have a legal obligation to repair. And here the landlord has never argued that it could not repair heat, refrigerator, toilet, mice infestation with Mr. Woodley in this unit. That's, of course, the bread and butter of housing law, the cases that we see all the time where landlords can make those repairs without doing a gut renovation of the building. So the landlord would need to establish under the statute that none of the repairs could be done with the tenant in the unit. And the landlord flatly did not do this here. Mr. Woodley said at JA 80, I keep calling the emergency line. I'm telling them my toilet doesn't work, my refrigerator doesn't work, there is a hole in my ceiling and there are mice everywhere. And they tell me they just want to renovate. And so this is the paradigmatic example of why the statute matters.
There's some evidence in the record that they have said we're doing a building-wide or a complex-wide renovation. And your point is, we don't know why that is. We don't know what the necessity of that is. To the extent other people have moved out, we don't know why they've moved out. There's a process for this. Follow the process.
Yes, all the landlord has said on this record, all its trial lawyer chose to put into evidence were letters saying, we are going to conduct a renovation of this unit or of this building rather, but there is no evidence that that renovation was required to maintain the very basic conditions of habitability that landlords are required to maintain all the time. It's irrelevant why other tenants left. What is relevant is that the landlord had a duty to Mr. Woodley. It breached that duty and it made an offer that nobody could reasonably be required to accept, in the same way that it's no defense to say to somebody who is out of a job, well, other jobs exist and we're going to impose this intolerable condition. Here, we're going to cut off your water to force you to accept it.
And maybe this is repetitive of the questions my colleagues have already asked, but just to put a pin on it, if I am a landlord and I come with, all the good faith in the world and buy a complex that is in terrible repair, but I buy it and I say, I'm going to renovate this complex and I'm going to, I need to move everyone out, but I'm going to relocate them and then bring them back, guarantee them a return to their housing. I follow the statutory process for doing all of that. And I follow the law to a T. And one of my tenants is not happy with my plan and sues me for damages. Can I say I followed the process and I went to the rental administrator and I got a plan and I gave everybody notice and I gave them the right to return, all of these things. Do you think in that instance a tenant can win damages against me for a breach of the warranty of habitability that I would concede the moment I buy the property is not, it really is not habitable, and needs to be renovated, and I've proved it along the way. Do you think that a tenant can win damages against me?
On those very different facts, yes. One modification that I would add is that the landlord has the
And why, I guess, like, and, you know, like, if the statute just says there's a duty of mitigate, is that not a mitigation question? I'm trying to figure out analytically why that would be right. Like, if you look at the statute and it imposes a duty of mitigation only on the landlord. And if you look at Javins and it says, you know, that the implied warranty of habitability cannot be waived or shifted and exists for the duration of the lease, right? So even while I am jumping through all the hoops to do the right thing, to get the approvals that I need to legally relocate people temporarily, this implied warranty of habitability applies. Why would someone not be able to sue me?
Yes, because this statute, so fitting it all together, Scoggins says move out is not a defense, and then or somebody's failure to move out is not a defense. I think that the statute modified that with F1, the statute that we've been discussing, and under those conditions, it would be reasonable for someone to accept that move out offer. One important distinction, though, is that as soon as the landlord enters into this relationship with the tenant, they have the duty to maintain the conditions, maintain a habitable unit for the tenant. And so it's no defense to say, well, we've started the renovation process, but it's going to take a year, so just hold tight. The tenant gets to recover as soon as the warranty of habitability is breached. And
That seems to suggest that I could be held, right? Like, what if there's just, like, you know, a problem with the roof? And and there's asbestos and I can't repair the roof with everyone there. And I know it, and I go through the whole process. But in the meantime, the roof is still leaking. There's still mold in the apartment. Like, I'm trying to encourage people to get out as quickly as possible. I've offered them, relocation. I'm doing all of the things, but I can still get sued. Is that your argument?
so the facts that you've described, I think, might fall under something like condemnation, or the problems are so severe that nobody can safely inhabit the building. And that's just not the facts that we're dealing with here. Broken refrigerator, ceiling, all horrible conditions, but they're ones that landlords are required to fix with tenants in them all the time. And if this court was to say otherwise, landlords could simply make the decision of, I'm going to allow these units to fall into disrepair. Tenants won't be able to sue me to recover. And instead, I'll just say, there's an alternative unit. Take it. It's better than what you're living with now. And that is not a business decision that landlords are allowed to make in the district.
Ask you, I know
Yeah.
you're over time, but I just want to make sure I understand what you think the record in front of the trial court was when the trial court ruled. Because with respect to the bench trial, nobody put on live testimony. It was, I guess, exhibits, if I understand. Now, there was a prior TRO hearing, and I took an argument that you were making that the record of that TRO hearing was not anything that the trial court really should be considering when rendering its ultimate decision. And I wanted to ask about that because it looked to me as though both parties were present at that TRO hearing, and the trial court's order with respect to the TRO hearing treated it also as a preliminary injunction, and which made it seem to me as though, at least in principle, the testimony from that hearing could have been made part of the record of that the trial court was ruling on when rendering its final decision. Am I missing something there, or what's your response to what was properly in front of the trial court?
Yes. So to the very first part of your question, Mr. Woodley did testify at the bench trial, and the landlord did not offer testimony or cross-examine him. To the question of the TRO, the issue in the TRO hearing was, is Mr. Woodley as movant entitled to the extraordinary remedy of an injunction? And that is not the question before the trial court in this case.
I get that, but that's
Yeah.
not my question either. My question
Okay.
is not so much what were the issues there. My question is, was the evidence that was introduced at that TRO/preliminary injunction hearing in principle available as part of the evidence that the trial judge in rendering final judgment after the bench trial could consider?
Yes, Your Honor. The landlord did not make any argument based on that evidence. And importantly, the trial court here did not make reference to the testimony or make the particularized findings that Walker requires.
I thought it's certainly true. I think that may be true, but the trial court did in its final order make some reference to things that had happened in the TRO hearing. Is that accurate?
Yes. So what the trial court did say is that at the TRO hearing or in the TRO denial order, the court found that Mr. Woodley had been given, quote, a reasonable accommodation. Reasonable accommodation.
I understand that's not the same as statutory compliance, and in your view is not a sufficient predicate to any duty to mitigate if one exists. So I follow all that legally. And I believe the following to be true, which is no party made a transcript, neither legal aid nor any party made a transcript of the hearing in front of the TRO/PI hearing available to this court.
That's correct.
And do you know whether a transcript was prepared and was available to the trial judge who rendered the verdict in the bench trial? Because I know that was a different judge than the judge in chambers who handled the TRO preliminary injunction hearing.
There's not evidence of that in the record.
It doesn't indicate whether a transcript was prepared or whether Judge Rigsby had it available and reviewed it in rendering his verdict. Is that what you're saying?
Right. And
The TRO order was given to him.
yes,
It's an exhibit,
yes.
but there's no indication that the transcript of the TRO hearing or the PI hearing, whatever you want to call it, was given to him.
Correct.
Okay. Can I ask you a question about damages?
Yes.
You have made a calculation of damages in your brief. Were we to conclude that Mr. Woodley should prevail, would you be asking for us to direct that the trial court enter that specific calculation? Or are you looking for a remand to the trial court to reconsider the amount of damages? As we've sort of talked about, the record at the hearing was not terribly robust. You've sort of guesstimated at when certain breaches occurred, but there are no findings of fact by the trial court as to when they occurred. And I'm wondering whether you would want those. Mr. Woodley also mentioned, outlay of resources to buy space heaters, and I didn't see that included in your calculations. I'm just sort of wondering, are you looking for a remand, or are you, by calculating that number, were you saying actually, this is the number that we think that is the correct number?
This court's practice is to remand for a redetermination of damages based on the record that existed at trial before, at the close of evidence, the trial court's legal error came after all evidence was entered. So we would say remand based on the record that the landlord's lawyer chose to put into evidence. You're correct that the trial court did not make findings about particular conditions at particular times, but the trial court did find that the unit was, quote, completely uninhabitable. The landlord agreed and did not counter any of the evidence that Mr. Woodley offered at trial about the time periods. So Mr. Woodley testified that the mice existed for at least 2 years, the collapsed ceiling at least 2 years, no heat for 7 years, a broken toilet for 1 year. And so all of that was before the trial court, and that is the record that the trial court needs to decide damages on. And you're correct, Mr. Woodley testified also about having to go to the grocery store every other day because of the broken refrigerator and buy space heaters because his unit was unlivable without heat.
I saw that your opening brief, the way you word the request for relief is for an award of damages in an amount or for recalculation of damages of not less than $22,788. And so
Yes.
it sounds like, and I gather that rests in part on your view that even in this court, the landlord hasn't contested that if there is no duty to mitigate that was applicable here, the amount would be at least 22,788. So it sounds like, at least in your original brief, you were asking us to tell the trial court you need to figure out damages, but the amount of 22,788 is what, was raised on appeal and uncontested on appeal. So you should take that as a given and work beyond that. Is that an accurate interpretation of what your opening brief indicated?
Yes. Thank you.
Thank you. We will give you some time, excuse me, on rebuttal.
Good morning, Your Honors. Chris Gowan on behalf of Woodbury Village. The appeal before you is predominantly a challenge to the factual findings by the trial court. I think the court's questions regarding the duty to mitigate.
Why do you say that? It seems like there's a basic legal question, right? The trial court said you have a duty to mitigate. I didn't actually see Woodbury Village Apartment argue that there was a duty to mitigate. It seems like the court came up with this legal concept itself. So there's now a legal challenge to, is there a duty to mitigate in this context? And Mr. Woodley is saying no. That doesn't seem like a factual question. It seems like a legal question that we need to answer.
Sure.
That's the predicate question, the threshold question.
And, I think Judge McLeese's hypothetical that he provided earlier is sort of on point here. The common law establishes a duty to mitigate. There's nothing in any case law that suggests that there is an exception to a tenant, and to hold such that where a landlord's coming in trying to repair a building and repair a unit that requires the tenant to leave, and if the tenant doesn't leave, the landlord, what else is the landlord to do?
Let's start with the statute first, right? Arguably, the statute abrogates the common law duty, right? Overrides the common law duty. Do you disagree? Right, there's a statute that says if a tenant refuses to take possession of a rental unit in bad faith or vacates a rental unit before the end of the lease term, any actual damages the housing provider may be entitled to shall be subject to the duty of the housing provider to mitigate actual damages for the breach of the rental agreement. And one could look at that and say, well, there's no need to legislate that. If you want, the common law duty already requires the non-breaching party to mitigate generally, right? And so if we just want the common law right to apply here, this statute is entirely superfluous. But arguably what this statute does is change the common law landscape and say, no, actually in the landlord tenant world, we have different rules, and we're just going to say that the only non-breaching party who has a duty to mitigate is the landlord. When the tenant breaches, the landlord has a duty to mitigate, and there's no mirror obligation on the tenant when the landlord breaches. Why wouldn't we read that statute this way?
I mean, I just don't think the statute addresses this situation. I think that's, we're talking about a situation where repairs need to be made. A landlord is trying to make those repairs.
Getting all into the facts, but I'm just
Right.
trying to understand as a legal principle, if we wanted to have a legal scheme where the tenant had a duty to mitigate, why would the council enact this statute? They could just rest on the common law and the cases that you cited to us in other scenarios and say that that's the way it rolls, everywhere. But this changes the rules of the game for landlord tenants.
I just don't think that language applies to this situation. The I think that was carved out for the specific scenario that the statute addresses. It doesn't.
It might not apply if the landlord jumps through all the hoops to comply with the other part of the statute, for how the landlord should direct a tenant to, vacate the premises and when repairs are going to be made in a long-term renovation situation. But what is the record on that? Do you think the trial court made findings that you had jumped through those hoops, or what's the state of the record on that?
Yes, and thank you. I think that's the ultimate question here. And, there's no question that neither party here today has the exhibits that were entered into evidence.
Well, wait a second. I thought Judge Beckwith's question was, did the trial court make findings that you satisfied your obligations under 42-3505-01 F1?
I was going to say that.
Yes.
Yes, my interpretation of the order is one that he found that the evidence submitted by the defense did sufficiently raise that. It's also important.
And
Part of the order, sorry.
What's that?
What part of the order says that?
That when the court refers to the preliminary injunction hearing in October 22nd, 2021.
okay,
and-
so again, let's just go back there then. Do you think that the judge in chambers made findings that the landlord had followed the necessary procedures under 42-3505-01 F1?
I do.
In her order, where is that?
So she addresses that Ferdinand Gamboa, the supervisor for housing inspections at DCRA, came and inspected the property and found that there was proper notification provided to plaintiff, and that he learned
Does
that.
he say that?
Oh.
I see her making a finding. Mr. Gamboa also learned plaintiff was refusing to leave despite the relocation accommodations.
And
That doesn't
DCRA
say that and DCRA then informed him that he needed to leave the unit, but that doesn't say anything about whether or not 42-3505-01 F1, right? It was complied with. Where's that record?
So-
Did you present that record to the judge in chambers in the PI hearing?
I wasn't counsel for
That's not helpful.
otherwise.
I
it wouldn't have the issues.
Lots of lawyers get up at the podium and they weren't the trial lawyers, but we expect them to know the record. So was that evidence presented? You want to rely on the PI hearing. Tell us whether this was in the record, whether the actual compliance, right? Was there a plan that was submitted to the rent administrator? Was notice provided to the tenants? All of the things, right? There are lots of things that need to happen for the landlord to be able to relocate people. Did any of that happen in this case?
Right. I believe it did. I don't believe the
don't-
courts would have
don't-
ruled the way they did if they hadn't shown that evidence.
Ruled incorrectly based on inadequate evidence,
Well,
right? And that's why we're here.
but
So
a preliminary
you
issue though,
would like
if I
to
can.
show us that there was actually adequate evidence for them to base their ruling, and I don't see it. I don't see it in the trial record that you've provided to us. And so I'm not sure that it's there.
But we don't know that it wasn't there either. And but preliminary, one major issue is that the compliance with this statute was never raised as an issue by the plaintiff. He never argued that we weren't.
The
that
plaintiff
there
was
was a.
pro se. And it seemed like suddenly the trial judge decided that his case for damages was also a case for you to possess the apartment, which I thought was very curious. And I thought was interesting that the lawyers didn't speak up and say, it isn't about whether or not we get possession of the apartment, because this isn't a possessory action. We haven't made a cross claim. We're not in landlord tenant court, right? But suddenly the court at the end of the hearing is saying, and I might order you to leave. And I'm thinking, on what basis and under what authority? And then he includes it in his order. I have no idea in a complaint that begins as a, pro se breach of implied warranty of habitability / discrimination claim for damages, where a trial judge gets the authority to tell a tenant that they have to leave. Do you want to tell me where that authority came from?
Right, so my interpretation of the order is that it relies on, he says that you've been trying this case for 3 years. We've heard all of these arguments before.
What did that, I saw that too, and I thought, what does that mean? This is the trial. So when
But
he
he's-
says.
but he's basically raised
he's
this-
saying you've been trying it for 3 years, what is he talking about? This is the
Yeah.
trial, and this is the point where he makes it very clear to Mr. Woodley, this is the time when you put forward your evidence. I need to know what your evidence is that you were damaged. And then they walk through it and Mr. Woodley testifies, right? But that's the point of the whole proceeding. So I just didn't even understand that statement.
Well, he cites to, he cites to 2 administrative proceedings that occurred, and then to the TRO preliminary injunction hearing. My understanding is the court would have the transcript and notes from
Was there
the,
any indication? I mean, the court got the order, the TRO order from you, not you, but your.
was entered
your
into evidence
predecessor.
without objection, yes.
Right. But there's no indication that the transcript was entered into evidence.
But my understanding is, it's the same case number, and so the court would have the records from that.
It's not as easy as you think. I mean,
Believe me.
trial judges don't just have access to go listen to hearings on the tapes, and they certainly don't have the ability to order transcripts to be created. They rely on the parties to do that.
If you say so, my understanding is the court can, gets would have the access to the real-time transcript that the DC Superior Court computers do, and that the notes and everything from the evidence that was put forth. We have several different courts opinions that have supported this position that the landlord has made reasonable efforts. There's 14 buildings. Every single member of all 14 buildings besides Mr. Woodley took the alternative housing that
Sorry,
was provided.
you said you've got rulings from other courts saying that the landlord had made reasonable efforts, or have those been cited to us in the briefs? Are you making some
Yeah,
sort of judicial estoppel or res judicata? Was Mr. Woodley involved in those proceedings? Like what does that have to do with this?
That it was part of the record, he cites to the HUD case and the other case in the footnote. And then there was the same exact facts and stuff were brought before the landlord tenant in LTB case. Judge Mattini issued an opinion there, again, saying that landlord has made reasonable efforts. That's in the supplemental appendix. The different matters that Mr. Woodley has brought against this landlord, or, we've supplied the dockets in the supplemental appendix regarding those cases. But I need to come back to one point, to suggest that because he's a pro se litigant, that he doesn't have to raise an issue at trial. I just don't see how that's fundamentally fair at all. I mean,
I'm sorry, what issue did he not raise?
there was
He came in, this is why I'm so confused. He came in and said, I have damages, and the trial court walked him through sort of eliciting his testimony about what his damages were.
he never.
The duty to mitigate comes up in the court's order. Nobody's he didn't have an obligation to preemptively say he didn't have a duty to mitigate. That's not what you're arguing, right? That would have been your burden to say he had a duty to mitigate. And you didn't say anything about, or your predecessor in interest, Woodbury Village, didn't say anything about a duty to mitigate at the hearing.
No, I didn't say anything at the hearing, at the trial, but
Is at at the trial, right? You admitted all of his damages. You didn't cross him. You just accepted everything that he said.
correct. And as did he for the 15 exhibits that the defense put on. But at no point did the plaintiff argue that, in fact, he argued the exact opposite, that he didn't need to get out of the unit for it to be repaired. We're hearing about all these horrible damages and it's completely unlivable. I think it's pretty well established that in order to make these repairs, they needed to come in and do a full renovation. And I do believe if this court has.
I mean, I hear you. I just don't see any evidence of that, right? And like, maybe that's true. It's just that evidence wasn't presented at the trial.
Nobody here knows that because we don't know what
Why do you say that?
because there were 15 exhibits presented.
We had the exhibits in your supplemental appendix.
No, we have what we've deduced as some of them, but neither counsel here knows knows the full extent of the exhibits. We really only know 4.
So you think, I counted at least a dozen. You think that there are missing exhibits that would have proved what?
They complied with, they've done
Complied with their
their
F1,
renovations.
recite the full statute again.
Right.
Obligations. And even
they've
though the
properly
board didn't
provided
make
reasonable
any findings
accommodations.
about that, but
And another point is that the plaintiff he admitted that the place was terrible and he admitted that he wouldn't even go look at the.
the exhibits show that. I guess I'm just kind of confused. Like if you never argued the duty to mitigate, but now you're saying your exhibits would have supported a duty to mitigate that you didn't argue.
I would say the exhibits show that they were in compliance with the statute as far as the remodel.
The statute that you never cited. It just seems implausible.
They were in
that's
compliance
those
with the law.
exhibits-
That they complied with the law.
Did you argue in your brief that the exhibits were incomplete and therefore, I didn't see this argument either.
We put that in, we mentioned that that the record here is incomplete. And I did mention that.
Can I ask you relatedly, you're making the point now that, which is a little hard to assess because we don't have the transcript of the preliminary injunction / TRO hearing. And then we have inferences you draw from orders, and I gather we have some exhibits, but maybe not all of them. You're making the point now at oral argument that I think, if I'm understanding it correctly, that in the order denying the TRO / preliminary injunction and in the bench trial, what the courts said was the landlord's efforts here of offering something else were reasonable. And if I take your point, it is to the extent someone is now developing the line of thinking that reasonableness isn't really the right test. There's a statute that requires specific things be done, and neither court really said, okay, I understand there's a statute here that will determine whether the landlord's efforts are reasonable and lawful, but not just sort of reasonable if there weren't a statute, but they're actually lawful. Nobody did that, but your argument today is, I gather, that that's just not a point that the tenant was making. And so you really shouldn't expect the trial courts to have zeroed in on it in that way. And Judge Easter has pointed out one complication about that is that argument relates to a duty to mitigate line of thinking that really doesn't seem to have been the party's idea, and it's more the trial court's idea. So that complicates your point. But I was also just curious whether you understand yourself in your brief in this court, leave aside what you're doing now at argument, but in your brief in this court to have said, to the extent that legal aid on behalf of the tenant is now raising this question of whether there was statutory compliance, that was not properly presented to the trial court and this court shouldn't consider it. I remember there being reference in your brief to the kind of disability accommodation piece of it as not having been raised in front of in the trial court, but I don't remember the point you're making now about sort of statutory compliance with the process for relocating tenants while you're doing repair work. Is that something that's in your brief and I missed it, or?
I believe it is in the last section of the brief, penultimate page, I believe. We raised that issue. That's it. Um, I mean, I guess I see the court's point, but I would say section 2 of the brief is addressing that these, arguments not made at trial, which, the appellant's brief starts out by making an issue about this first floor, third floor thing, and then sort of retreats from that in their reply to mine. Now we're bringing up a statute that, it simply wasn't, the statute, a statutory violation was not, that was no accusation in any of the pleadings in the pretrial statement, or a trial was that made on the defendant.
You don't really know who was saying what at trial. I mean, we don't have a transcript of, to the extent part of the trial record was the preliminary hearing, TRO hearing. We don't have a transcript. We don't really know what people said about that, except we have an order from the judge in chambers recounting some of the things people said, but we don't really know exactly what all went on at trial because we don't have a full record of what happened in the trial court. If I gather we're missing some exhibits and we don't have transcript. I mean, we have no transcripts of anything available to us right now. So it's a little hard to assess an argument that arguments weren't made because we don't really have the record about who said what at these these court proceedings.
We know we have the trial transcript, so we know there was no argument made about the reasonableness of the compliance with the statute. We know it wasn't made there. We know it wasn't made
I guess
in the complaint,
excuse me,
and
excuse
it wasn't raised at the preliminary.
counsel. I'm wondering why Mr. Woodley, as the plaintiff in a discrimination / breach of implied warranty of habitability claim, would bring up 42, 35, 05, 01, F1, even if he were represented by counsel, right? Like, why would he affirmatively bring that up? His argument is, I'm in the apartment. There's this warranty of habitability. It has been breached. It seems like that could be an argument that the landlord could bring up to say, we have been trying to move him out. We have jumped through all the hoops, right? But there is no argument by the landlord at the trial that they have done that. And I guess you want to point us to the PI transcript, but in your brief to this court, you focus on the PI order, but you don't say what you really need to look at is the PI transcript. And I mean, I guess I'll just ask you as you stand here today, have you read the PI transcript? And can you tell me, so you don't know?
I know what the court found. We have the court's findings, which has
said in its order. Okay.
Right, which found that there were reasonable accommodations made. And so it's, when the defense puts on evidence, which they clearly did at the TRO, and presumably that was what the documents were, the exhibits at trial, when they make that argument that we've tried everything we can, we need to get in here and repair it. He needs to be out. We got him a separate place. Then he said, no, I need money. So we gave him $5,000 and he wouldn't take that either. Now, at that point, that's when the plaintiff should say, well, no, I don't have to leave the place for them to fix it. It's not that serious. It only needs a little. But he said the opposite of that. He kept saying it's terrible. It's so bad. And counsel has reiterated how bad this property was, all bolstering the fact that he needed to be out for it to be
I
repaired.
don't see where he said, I have to leave. I saw him say at the TRO, I want you to turn my electricity back on or give me $5,000 to stay in a motel while this litigation is resolved.
Right.
And I don't see that as a recognition that his apartment, that he had to vacate the apartment for the renovations to be done. He just said, while this is happening, I want to be in a motel. That's all he said.
Right. So he didn't argue that that him leaving wasn't necessary. And he needs to
I
do
got
that.
lost in the double negative, sorry.
Right? Like, so
He didn't argue that him leaving wasn't necessary.
exactly. And so after the landlord put on evidence that the DCRA inspector came, checked out everything and said that it all checks out and that you need and inform the plaintiff that he needs to leave the unit. At this point, the plaintiff should say, well, no, I don't need to leave the unit because they could fix the ceiling while I'm in this room or that. He doesn't make any of those arguments.
Ms.
And so-
Swanson has made that argument several times.
What's that?
today. Ms. Swanson is making that argument several times today that all of the things that are wrong are the bread and butter of landlord-tenant contests and could have been fixed while he was still in there. I mean, she's making that argument today.
It wasn't made at trial or at the preliminary injunction. So to then say that now the
Because
tenant,
the landlord.
the
didn't
landlord
make
has a
that
duty-
Argument at trial, right? Like maybe that was raised in the context of should he get an injunctive relief? But the landlord didn't make that argument at trial. So he didn't respond to an argument that wasn't made at trial. Can we move to damages really quickly? I didn't see an argument if we disagreed with the landlord and thought that the $7,500 damages award needed to be reversed. I didn't see an argument from the landlord that the alternative figure that Mr. Woodley proposed was incorrectly calculated. Are you disputing that figure?
yes, sir. I don't believe there's any basis for that calculation.
So
And
you, you would think we needed to remand?
if we think that's really necessary to find out what these exhibits were and to get a better record, the only proper resolution here would be a remand. I think that would be an unfortunate result.
Do you
And
think we would get a better record to calculate the damages?
right, but both, will we get a better record to see whether the
You
court-
haven't cross appealed on the breach of the implied warranty of habitability. So that's not before us. The only question is, how much money does Mr. Woodley get?
well, no, but there's also an issue of whether what those exhibits were and whether
Why would we get to that? I mean, unless you're saying that that's going to inform what, right? If we say.
the landlord was in compliance with the statute and that the court had already made it took evidence that supported that. And that and additionally, that the plaintiff never contested any
I
of that.
didn't see an argument in your brief that that's what should happen. I just don't see that in your brief. So that argument seems forfeited to me.
What are the
That you were in compliance with F1. I don't see an argument in your brief that you were in compliance with it or that there was record evidence in the trial court
Okay.
that would show that.
I disagree on it. We point to the TRO preliminary injunction hearing and the
I
testimony.
know you point to that, but
Okay,
is
well,
is
that's-
it in the context of saying that you were in compliance with F1? I'm saying F1 is, I guess I have the movie in my head, but as shorthand for the statute that sets forth the procedures for relocating a tenant for gut renovations. I just don't, I didn't see, if you want to point me to where that is in your brief, I'd be happy to see it, but I don't see that.
Your Honor, it's our position that the evidence taken by the court in the preliminary injunction establishes that, and as would have the 15 exhibits. If this court can get those 15 exhibits, that would probably resolve this whole argument here today. And, I've made requests, numerous, and I don't know if that's going to get followed through with, and this court will get the full record of what those exhibits were. When you look at the pretrial statement, that was the joint pretrial statement, it says see exhibit list, and then it clearly shows that they instead of the next page should have been the exhibit list, and they just have the second page of the pretrial statement there again. And so there is an exhibit list somewhere. I believe that this court can get it. I know that we cannot get it because we have made tons of efforts.
You said you've made requests of this court?
No, we made requests of the trial court.
Hey, just to make sure I understand, I mean, I know the joint appendix has a whole slew of exhibits, so there's a bunch of exhibits that we do have access to. You're saying I mean, do you have exhibit numbers at hand of the exhibits that you think were entered into evidence and that would shed light on the topic that you're focused on here?
I think exhibit 1 is referenced in the either in the court's order or in the transcript, that there is the renovation notice.
We have that in your supplemental.
Right. And then
appendix, right?
there is an exhibit 9, which is an additional notice. I don't know that those are the exact ones. And then, but we don't know what exhibits 2 through 8 were. We know that exhibits 13 and 14 were either transcripts or holdings from one from an OHR finding and another from an HUD finding. And then that I believe that exhibit 15 was an inspection, but so there's several exhibits that neither council knows what they are.
You know that they were physically introduced
Yes,
and then just disappeared.
correct. I would love it if we could scan exhibits.
I'm gonna just read to you one more time the table of contents from your argument. A tenant that prevents an owner from making repairs after an owner provides proper notice fails to mitigate damages, which exempts the owner from liability at that point. Preventing an ownership from making repairs violates the DC code, affirmatively proves a breach. Tenant isn't required above $7,500 awarded by the trial court under the clean hands and avoidable consequences doctrine. Where does it say that you complied with 42-35-05? No.
Again, Your Honor, this is,
I mean, I just don't see that argument in your brief, but that seems to be a big part of your argument now, is actually we proved it. And you would think that
no, the argument is that one, they didn't, the plaintiff never made this allegation. There was never an allegation that there was a statutory violation.
but
Why did defend?
they raised it in their brief. And in your brief, you didn't say anything about it.
This is appealing a trial court So there's no pleadings by the plaintiff at the trial court level. At no point in the TRO, there's 6 or 7 hearings. There's no record of the plaintiff ever making an allegation that the defendant wasn't in compliance with that statute. My suggestion
Right,
is
and he
that
wouldn't have, because he was seeking damages. That was, he wasn't arguing that you weren't following that statute. He was saying, I'm in an apartment where the warranty of habitability has been breached.
right, but then we were clearly saying, and I just really credit the testimony from the housing inspections office that said they reviewed everything, looked at it, and concluded they withdrew the penalty and told the plaintiff they needed to leave. I mean, if there was a statutory violation, I believe
That's
he would have
exactly
said
what he
that.
That seems like an enhancement of what he.
You're suggesting that a member of DCRA went and inspected this property, reviewed the documents, and if he had seen a problem, a statutory violation, he would have just ignored that and said the plaintiff needs to leave. I mean, that's preposterous.
I have no idea whether he's the guy who follows all the procedural requirements and makes sure that the plans have been filed, and he might be the person who goes to inspect the apartment to see if there's a problem with the apartment. But I don't know whether he is the person who keeps track of the paperwork.
I don't know why.
Do you know if he's the person that keeps track of the paperwork?
It's certainly my understanding that the housing inspections group would be the body to make that determination. I think that's something the court can, there's an answer to that question, I guess. But again, I don't understand how we're putting a burden on the defense to prove something that wasn't alleged against them.
Well, I
And
guess at the first level, it's more complicated than this in a sense, but I think the judiciary's questions are tending in the following direction, which is if the point of if the tenant comes in and says, I'm in an uninhabitable residence and the landlord owes me damages, and the landlord says, well, even if that's true, here's the situation. We've offered to get you out and you shouldn't be able to get damages for living in an uninhabitable place, even though there's an applied warranty that you won't have to do that because we're giving you a reasonable offer. I would think it'd be the landlord's burden. I mean, that's sort of a failure to mitigate some kind of a landlord's response to a claim of damages. And then what gets more complicated is if the landlord's answer to that is inadequate because it may not be enough that it's reasonable in the abstract. If there's a statute which governs the legal way to do that and the landlord did or didn't do it, then the questions start getting confusing about, well, then who the landlord teased the issue up as, well, you shouldn't get damages because we're reasonably trying to solve the problem. Is it the burden then shifts sort of back to the tenant to say, well, that's not the right way of looking at it. Mere reasonableness is not enough. In fact, you also have to comply with the statute, and you haven't shown that you did. And it's hard to assess all of that for 2 reasons, one of which is we don't have a full record of all the relevant materials. The other of which is just wrapping back around to what weight to give to who makes what arguments when, is that at least I haven't been able to find in your brief in this court an argument that the lack of statutory compliance is an issue that wasn't properly presented in the trial court. And so sometimes if you're a litigant and your opponent raises arguments that should have been raised in the trial court, but you don't point that out in your brief, we end up thinking that you can forfeit a forfeiture and that will sort of sort the issue out rather than allowing belated arguments about how other people weren't making their arguments in a timely way. So that's the other piece of it that I'm finding complicated.
I mean, I would suggest that 2 things. One is I would suggest that the brief of Mr. Woodley's brief initially focuses on this first floor, third floor. And then in reply to our brief, they now lean in on the statute. And so, if the court will allow us to submit a supplementary brief, we can address those issues.
Right, so just to be clear, I think in Legal Aid's initial supplemental brief at pages 6 to 7, they say there's a statute that governs how you're allowed to relocate people if you think that you've got a problem in their apartment. The landlord did not represent that it followed any of these or the law's other procedures in seeking to evict Mr. Woodley. So, and then you filed a responsive supplemental brief where it would have been available to you to say, well, that's an interesting line of thinking, but it's really something that ought to have been presented in the trial court. And that would then have allowed briefing of the question of, well, was it? And do we need a record that is more extensive than we have to assess that? And also, really, was that something that was incumbent on the tenant if the whole issue of mitigating damages was sort of raised by the trial court? So that would have been a bunch of issues that we could have had briefing on that we don't because of how the matter got litigated in this court, it seems like.
Okay, but that doesn't change the record, right? The record is clear that these arguments weren't made.
Well, how is that clear? Because we don't have, we do have a transcript of the trial, but we don't have a transcript of what was said or argued at the
TRO hearing.
at the TRO PI hearing.
We know, we have the complaint, the amended complaint, the joint pretrial statement, and none of those documents suggest that there is a challenge to whether or not he needs to move out for these repairs to happen, or whether or not the repairs, that the relocation, remodel efforts by the landlord are not in compliance with DC law. Nothing says that. And so now we're saying that the defendant should have known they had to prove that when it wasn't even raised at trial. I'm not sort of following that logic at all. And I think it's fundamentally unfair. It's very frustrating that the court didn't at least read into the record what the exhibits were. And, there wasn't more argument provided by our counsel at trial as to what, the position is, and just relying on the submission. It's also very frustrating that counsel doesn't have the exhibits. But that doesn't change the fact that we do know some things, and we do know what, the notice pleadings provided by the plaintiff never suggest that, his pleadings and his whole case in chief is saying, it focuses on the dog not being able to go into the office, and that the conditions were bad. He never argues that he admits that he didn't even go look at the remodel, the alternative location. There's nothing in here that suggests that the plaintiff ever said he doesn't need to leave. They can make the repairs. That's not something he's ever even proposed or offered. And so now, but back then they should have known that this day would come and make those arguments. I don't see how that's remotely fair to a litigant here. And just following on the he's pro se, again, I don't, the record's still the record, and the defendant can't be expected to put on a case that doesn't, where they weren't, those accusations weren't made against them. So the court's opinion at the preliminary injunction, I don't know how there can be any other reading that there was, that the court was very convinced that the landlords were doing things right here, and that the tenants' issues lacked merit. And then, lastly, I'll say that, I do want to point the court to the Lynch case, where, they say a lease may also become void after the tenancy begins. This occurs when housing code violations arise and render the unit unsafe or unsanitary, if they do not result from the intentional acts or negligence of the tenant. So, there, the court seems to be applying that there is a duty to mitigate a reasonableness from the tenant. There's just there's no opposition to the factual. The defendant never argues that the property doesn't need to be fixed, and he also admits that he refused to leave the property. And we know that the rest of the tenants did, of 14 buildings, all did that. And so it's just, I think this court can rely on the court's findings and, the full record. I don't know if the record that this court will get will include those exhibits. And, I'd ask for leave to submit, we can submit a follow-up brief about what, to do some research as to what the court would have access to regarding transcript from the preliminary injunction. My understanding is that the technology in DC Superior Court, from the cases I've tried there is real-time transmission, and that stays there, and the court can always go back and look at those records. And I believe this court can do that as well, whereas the litigant cannot. And so that's and to your point, I don't think the damages, there's any basis for their damages. And so, if the court's not satisfied with the record here, then a remand to clear the record up as to what the exhibits were, the statutory compliance, that sort of thing, okay. But again, when the plaintiff didn't even make that argument, I don't know how the defendant should have been on notice to argue that they were in compliance with the statute. Thank you.
Thank you, Mr. Gowan. Ms. Swanson, we will give you your 3 minutes.
I'm happy to answer any further questions that the court might have.
Do you have any insight on the missing exhibits question? I mean, do you, have you all looked into that topic, or any thoughts to share on that topic?
Sure. So the exhibits were returned to the landlord's lawyer. I do not know what the landlord's lawyer did with those exhibits. The trial court found at page JA7, quote, defendant does not contest that plaintiff was living in substandard housing, end quote. That is a finding based on the record that existed before the trial court. The landlord's lawyer chose to try this case a particular way 3 years ago when Mr. Woodley did not have a lawyer, did not make argument, it did not contest the conditions that he was living in, and this court should remand for a recalculation of damages of not less than $22,788, as we've argued in our brief, based on the record as it existed. The legal error was made after the record closed.
Thank you very much.
Thank you.
Besides for your arguments today and your briefs, the case will be submitted and we are adjourned.